start. The petitioners in this writ petitions who are engaged in the manufacturing and sale of all kinds of spirituous preparations besides allopathic tinctures challenge the right of the state government to collect fees for assaying the company's products and the costs of excise establishment deputed to supervise the operations of the companies concerned. Learned counsel appearing for all these petitions, as well as the learned advocate general appearing for the state, the respondent in all these matters have agreed to treat the pleadings as representing the stand taken by the various petitioners regarding their grounds of attack against the levy in question, as well as the stand taken by the state government to justify the said levies. Therefore, I will refer to the averments in the pleadings in the said writ petition, as well as the exhibits filed by the petitioner and the state government in that matter. The government have been pleased to grant the privilege of manufacture and supply of all kinds of spirituous preparations besides allopathic tinctures, subject to the various terms and conditions mentioned therein. Though there are several clauses in the said agreement, it is not necessary to refer to all of them because the controversy relates only to the levy on the basis of some of the conditions in the agreement. Therefore, I will advert only to the relevant clauses in the agreement. In clause 1 of the agreement, the petitioner has been authorized by the government to manufacture and sell all kinds of spirituous preparation besides allopathic tinctures. Clause 4 of the agreement provides for the company sending free to the research department of the University of Travancore samples of all preparation manufactured by the company, and it is further provided that the research department will assay the preparations on payment of such fees as may be fixed by the government from time to time, and that the said department will certify as to the spirit content of the preparation. Under clause 9, it is provided that the company agrees to pay to government 10% of its annual net profits, and it also provides as to how the net profit is to be calculated. Clause 32 makes provision for any dispute arising between the government and the company being referred to the decision of two arbitrators, and it also provides the manner in which the arbitrators are to be nominated. It also makes provision for the nomination of an umpire in case of difference of opinion. At this stage, it may be mentioned that the controversy relates to the right of the government to collect the amounts provided for in clause 4 and 17 of the agreement. So far as the payment of 10% net profits to the government provided for under clause 9 of the agreement is concerned, that has ceased to be a subject of controversy at present in view of the statement in the counter affidavit made by the government in paragraph 3 that the condition provided for in clause 9 has been dropped with effect from 1/4/1061. In fact, a copy of the order passed by the government in this regard, it will be seen from Exhibit R2 that representations appear to have been made to the state government protesting against the collection of 10% net profits under clause 9 of the agreement, as also the collection of cost of the excise establishment under clause 17. But the government passed orders exempting only payment of 10% of the net profit with effect from 1/4/1961, but they declined to waive the recovery of the costs of the excise establishment. In fact, it will be seen that this order was fled in this court. That is why the petitioner has also claimed relief in respect of the collection of this 10%. But as I mentioned earlier, this does not now arise for consideration. Stop.